Every time you tap a screen to order a package, stream a movie, or search the internet, you are interacting with a digital market shaped by invisible boundaries on corporate dominance. We assume that when a single technology giant or retailer tries to buy up all its competitors, a government regulator will step in to review and potentially block the monopoly. But the United States had no nationwide federal antitrust law to break up these massive conglomerates until 1890. Before the introduction of the Sherman Antitrust Act that year, who exactly decided how large and powerful a private enterprise was allowed to become? Without a national standard, nothing explicitly stopped a handful of men from capturing an entire continent's supply of oil, steel, or rail transport. This is a story about the raw architecture of power and whether a democratic government could survive when private corporate networks grew wealthier than the state itself. In the decades immediately following the American Civil War, the national economy transformed from a patchwork of local artisans into a continental machine. By the 1870s, telegraph wires and iron rails connected distant markets, creating the first opportunity for truly national supply chains. But the legal system governing businesses was still stuck in the 18th century. At the time, there was no such thing as a federal corporate charter. Instead, a company had to ask a specific state legislature to grant it a piece of paper called a corporate charter, which strictly defined what the business could do. These handwritten state ledgers intentionally limited the total capital a company could raise and explicitly forbade a corporation from owning stock in another company. If a state felt a company was growing too powerful or acting outside its chartered purpose, the state's Supreme Court could simply revoke the charter and dissolve the business. This localized system worked perfectly well for a local grist mill or a regional toll road. It was entirely unequipped to handle a sprawling network of oil refineries operating across dozens of state borders. John D. Rockefeller and his partners at Standard Oil recognized that state legislatures were a bottleneck to their ambition of total market control. By 1879, Standard Oil secretly controlled nearly 90% of the oil refining capacity in the country, but legally, it was just a collection of separate state-level companies. They needed a legal fiction to centralize this empire without triggering state-level corporate death sentences. The solution arrived in 1882 through the brilliant and highly secretive legal engineering of a corporate attorney named Samuel Dodd. Dodd realized that while a corporation could not own another corporation, a human being acting as a trustee could legally hold property for someone else. He drafted a completely private legal contract known as the Standard Oil Trust Agreement. Under this physical contract, the stockholders of 40 separate oil companies physically handed over their shares to a board of just 9 trustees. In exchange for surrendering their voting power, the original owners received handwritten trust certificates that entitled them to a share of the combined profits. The 9 trustees now held total, unquestioned, dictatorial control over a nationwide empire, while remaining invisible to state corporate regulators. Because this trust agreement was a private arrangement between individuals, it did not require a state charter or public disclosure. The 9 men met in secret at 26 Broadway in New York City, setting national prices, assigning production quotas, and ruthlessly crushing independent refiners. The trust structure effectively bypassed the entire American legal system, creating a private monopoly that answered to no government. The success of Standard Oil triggered a massive wave of corporate imitation throughout the 1880s. Soon the American public was buying their necessities from the Sugar Trust, the Whiskey Trust, the Cottonseed Oil Trust, and the Lead Trust. Prices for basic goods were suddenly being dictated by shadowy boards of trustees operating completely outside the bounds of free market competition. Farmers in the Midwest and South were among the first to feel the crushing weight of these unregulated monopolies. When they brought their crops to market, they faced railroad syndicates that set predatory freight rates, knowing the farmers had no alternative transport. The agrarian populist movement began demanding that someone, somewhere, step in to restore the balance of power. Individual states attempted to fight back by taking the trust to court under ancient common law doctrines against restraints of trade. State attorneys general filed massive paper briefs demanding the dissolution of these combinations, and in a few cases, they actually won. But a trust dissolved in one state would simply reorganize the next day across the border in a more lenient jurisdiction like New Jersey. It became overwhelmingly clear that a patchwork of state laws could never contain corporations that operated on a national scale. The trusts were exploiting the very nature of interstate commerce, using the physical borders of the states as shields against regulation. The American public realized that only the federal government possessed the geographic reach and constitutional authority to challenge these new industrial titans. By the presidential election of 1888, the public outrage over corporate monopolies reached a boiling point. Both major political parties recognized that ignoring the agrarian and labor coalitions was political suicide. They each rushed to include anti-monopoly planks in their official campaign platforms, though neither party knew exactly how to legally enforce them. The task of translating this public anger into federal legislation fell to Senator John Sherman of Ohio. A veteran Republican statesman and former Treasury Secretary, Sherman viewed the massive industrial trusts not just as an economic problem, but as a direct threat to the American Republic. He famously warned his colleagues that if the country would not endure an emperor as a political power, it should not submit to an autocrat of trade. In December 1889, Sherman introduced a legislative draft designed to break the power of the corporate syndicates. His proposal, officially filed in the Congressional Ledger as Senate Bill 1, was remarkably brief and intentionally sweeping. It sought to weaponize the Commerce Clause of the United States Constitution against the shadow empires of Wall Street. The proposal triggered months of fierce debate on the Senate floor regarding the exact boundaries of federal power. Lawmakers meticulously revised the text, terrified that a poorly worded statute might accidentally outlaw labor unions or legitimate business partnerships. The final handwritten parchment that emerged from the Judiciary Committee created an entirely new category of federal crime. The core mechanism of the new law attacked the very foundation of the trust system. The printed legislative text explicitly declared that every contract, combination, or conspiracy in restraint of trade among the several states was strictly illegal. This meant the secret agreements signed at 26 Broadway were no longer just private contracts, but federal offenses. The law also introduced severe penalties for the individuals orchestrating these monopolies. Federal court dockets were now authorized to issue criminal indictments against any person who monopolized or even attempted to monopolize any part of interstate commerce. Executives facing these charges could be punished with steep financial fines or up to a year in a federal penitentiary. With public pressure mounting, the final bill passed both houses of Congress with nearly unanimous support. On July 2, 1890, President Benjamin Harrison signed the Sherman Antitrust Act into law. For the first time in its history, the United States possessed a nationwide federal statute designed to regulate the size and behavior of private enterprise. However, passing a law and successfully enforcing it proved to be two entirely different challenges. The corporate attorneys who had engineered the original trust structures immediately began searching for legal loopholes in the new federal boundaries. They found their escape route in the corporate laws of New Jersey, which had recently legalized a new entity called the holding company. Unlike the secret trusts, a holding company was a fully legal corporation explicitly chartered to buy and hold the stock of other corporations. The state-issued corporate charters from New Jersey allowed a single board of directors to legally merge dozens of competitors into one massive corporate show. The monopolists simply dissolved their vulnerable private trust agreements and immediately reincorporated as legal holding companies. The federal government's ability to stop this new tactic faced its ultimate test in 1895. The Department of Justice filed a major lawsuit against the E.C. Knight Company, a massive conglomerate known as the Sugar Trust. The federal prosecutors argued that the company's recent acquisitions clearly violated the new Sherman Act. The government submitted physical stock transfer records proving that the conglomerate now controlled 98% of the entire sugar refining capacity in the United States. They argued this near-total consolidation of manufacturing facilities was an obvious and illegal restraint of interstate trade. The case advanced all the way to the United States Supreme Court for a final, binding decision. In a devastating blow to the federal government, the Supreme Court ruled firmly in favor of the Sugar Trust. The published judicial opinion declared a strict legal distinction between the act of manufacturing goods and the act of trading them across state lines. Because the refineries themselves were stationary factories located within individual states, the court ruled they were exempt from federal interstate commerce laws. This disastrous ruling effectively neutered the Sherman Antitrust Act for the rest of the decade. The federal government was left holding a law that looked powerful on paper, but was functionally useless against the new manufacturing giants. Corporate America immediately recognized that the Supreme Court had just signaled an open season for industrial consolidation. What followed was the largest wave of corporate consolidation in American history, lasting from 1895 to 1904. Protected by the E.C. Knight decision, over 1,800 independent manufacturing firms vanished, swallowed by giant holding companies. The attempt to restrain corporate power had paradoxically accelerated the creation of even larger, legally fortified megacorporations. For the average citizen, this unchecked merger wave meant dealing with absolute monopolies for virtually every household necessity. The monthly expense ledgers of working-class families showed stagnant wages colliding with artificially inflated prices for coal, steel, and transportation. The federal government seemed entirely paralyzed, leaving the public to wonder if any president would ever dare to challenge the new corporate monarchs. The political paralysis finally broke in September 1901, following the assassination of President William McKinley. The sudden swearing in of Vice President Theodore Roosevelt placed a fierce critic of corporate consolidation directly into the Oval Office. Roosevelt believed that the United States government, not the wealthy industrialists of Wall Street, must be the supreme power in the country. He immediately ordered his Department of Justice to resurrect the dormant Sherman Antitrust Act. Their first target was the Northern Securities Company, a massive railroad holding company recently organized by the powerful financier J. Pierpont Morgan. The conglomerate threatened to monopolize all rail traffic across the northwestern United States, choking off vital agricultural shipping routes. The legal attack utilized a specific mechanism designed to bypass the corporate-friendly state courts. The federal attorney general filed a formal bill of equity directly in the federal circuit court in St. Paul, demanding the immediate dissolution of the holding company. This legal filing argued that the mere existence of the holding company constituted a conspiracy to eliminate competition. The corporate titans fought the government for 2 years, bringing the case before the United States Supreme Court in 1904. In a landmark 5-4 decision, the justices finally restored the teeth of the Sherman Act. The printed majority opinion explicitly declared that no corporate charter granted by a single state could shield a monopoly from federal interstate commerce laws. This victory launched Roosevelt's reputation as a trustbuster and triggered dozens of new federal lawsuits against the remaining industrial giants. The most significant reckoning arrived in 1911, when the federal government finally cornered John D. Rockefeller's empire. The Department of Justice presented over 12,000 pages of witness testimony detailing Standard Oil's ruthless tactics against independent competitors. The Supreme Court ruled that Standard Oil was an illegal monopoly and ordered its immediate destruction. The official court mandate physically divided the conglomerate into 34 entirely separate, independent companies. This historic document legally severed the massive corporate network, forcing the newly fractured companies to compete against one another in the open market. However, the 1911 ruling also introduced a critical legal standard known as the rule of reason. The published judicial text established that simply being a large or dominant company was not automatically illegal. Instead, federal courts would now analyze the specific ledgers and business practices of a corporation to determine if it had achieved its size through unreasonable, predatory tactics. This nuanced legal standard definitively answered the question of who decided how big a company was allowed to get. The American system rejected both the total control of private billionaires and the absolute prohibition of large-scale enterprises. From that moment forward, federal judges and government regulators became the permanent umpires of the American economy. The legacy of the Sherman Antitrust Act fundamentally reshaped the balance of power between private wealth and public authority. The aggressive enforcement broke the absolute dictatorship of the trusts, lowering prices for consumers and reopening the market to smaller competitors. Yet the corporate architects simply adapted, shifting their strategies from brute force monopolies to complex mergers and subtle market dominance. The breakup of Standard Oil ironically made its founders wealthier than ever, as the combined stock value of the 34 new companies skyrocketed. But the structural victory belonged to the federal government, which proved it could successfully dismantle the most powerful private institution on earth. The era of the untouchable corporate trust was permanently extinguished by the enforcement of federal law. Today, this exact same architectural tension governs our modern digital economy. When federal regulators investigate the major technology platforms or attempt to block the merger of massive retail chains, they are relying on the legal foundations established in 1890. Looking at the immense scale of modern digital conglomerates, do you believe our current antitrust laws are still sufficient to prevent monopolies? Or have these modern companies successfully outgrown the century-old federal boundaries? Understanding the hidden origins of these legal architectures reveals exactly how our modern commercial world was engineered. To continue uncovering the secret historical frameworks that dictate our daily lives, subscribe to our channel.